Good day, students. Thank you very much for joining this discussion, or as you can see on the screen, overview of study units 8 to 9 for the module Pvl3701, Property Law. My name is Prof. Ina Knobel. I'm one of the lecturers for this module, and I will be talking to you briefly about possession and holdership. I specifically highlight the word overview because today, as you are listening to this, and the way that I will be presenting this discussion is based on the assumption that you already read and studied most of the work, and that this is just basically going to highlight some aspects of these two study units to you. So let's start. You will hear while I'm talking, you might hear some paging. I have my study guide here in front of me, and I also want you to have yours, whether it's your an electronic version of the guide or a hard copy, it doesn't matter. But the best way of listening to this recording will be to actually also page in your study guide as we go along. Okay, the first thing that you see on the screen there is that I'm referring to a recap of ownership or possession or holdership. Now, up to this point, we've introduced you to some of the key concepts that are dealt with in study unit 1 and 2. You've heard something about ownership, of how ownership can be acquired, how ownership can be protected, and also how ownership can be limited. So this is now a follow-up on that. What is very important for any student, and I'm sure you as advanced students know, that it's always important to understand where a certain area of the work that you are dealing with actually fits into the bigger picture. It's never a good idea to only study certain study units in isolation. In other words, you can't really say, I'm going to study unit 8, and then I'm going to study unit 10, and then 15, or 14, or 1. This study guide follows logically, and it follows a very logical structure. So I would really recommend that you don't jump in between study units. Okay, so the first thing that I want you to, while you are listening to this, is to just look around you, wherever you are sitting, and look around and see everything around you. Where I'm sitting now in my study, I can see many books, I can see my cell phone, I can see a computer, I can see a glass of water, I can see numerous things around me, and everything that I see, somebody, which is me in this instant, has a real relationship with all these things that I can see around me. Now, you've dealt with real relationships, and I want to take you to page 12 of your study guide. There in paragraph 2.3.2, we write that a legal relationship is a relationship to which the law attaches consequences. Where the object of a legal relationship between legal subjects is a thing, we refer to a real relationship. A real relationship is the particular legal relationship between one or more legal subjects and a thing. If we go back to what I said earlier, the legal subject here would be me, and I have many things around me and I have some kind of relationship with these things. This relationship has certain implications for the legal order. Note that the concept of real relationship is broader than the concept real right, since real relationship include both real rights and certain unlawful real relationships. Now you might ask, if we go back to my example, is it possible that I have some kind of unlawful real relationship with some of these things that I mentioned earlier? Now, hopefully not, but that might be an example where, let's say, for example, I took something from a friend of mine, not knowing that it actually doesn't belong to me. For example, a cell phone that looks very similar to my cell phone, or maybe a beautiful pen that I saw and I thought it looks like one that's mine, but in fact it's not. And I picked it up accidentally and I take it home. That relationship with that pen or that cell phone might be unlawful. Now, further in paragraph 2.3.2, we wrote there are usually two sides to a real relationship, namely the subject-object relationship between the particular legal subject and the particular thing, and then the subject-subject relationship between the particular legal subject and other legal subjects. A real right is therefore always a dual relationship, the subject-object and the subject-subject. In certain cases, real relationships may take on distinctive characteristics, with the result that the rights and duties ensuing from these relationships may vary. We therefore distinguish between different kinds of real relationships on the basis of the ensuing rights and duties. In principle, a legal subject may acquire rights from a real relationship only if it is lawful, that is, if it complies with the legal rules. A legal subject will not acquire any rights from unlawful real relationships, although the relationship as such may still have consequences for the law of things. And then there in that same paragraph, we refer you to study unit 9, and we refer there to the example of something that is stolen. Now, if you look on the very next page, on page 13 of the study guide, there we provide you with an overview of ownership, possession, and holdership. Now, these words might sound very, I almost want to say they sound strange, because we understand what the concept of ownership means now, but when we talk about possession and we talk about holdership, they are confusing concepts, to say the least. Now, many students have asked me over the years that I've been teaching this module, how can we say that there's a difference between possessing something and holding something and owning something? And the aim today is for me to and as I said earlier, I'm assuming that you already read the study unit and that you already understand most of what I am talking about now. But what I want to do is to try and explain this distinction that we make between an owner, a holder, and a possessor. To try and explain it to you in a simple and understandable way. Now, I think the first thing that I want to say, and it is also mentioned in study unit 8, is that when we say that I am the owner of a car, does it mean that I am not a possessor as well? Because if I say that I own my car and I drive around in that car, it says something about my entitlements. Remember, we learned in study unit 3 that as an owner, you have a real right, which is a very comprehensive real right. But that real right gives you certain entitlements. It gives you the entitlement to control or to possess your car or your thing that you own. So when we talk like that, obviously, there's nothing wrong with saying that as an owner, I also control my property. What we do here is when we distinguish between an owner, a holder, and a possessor, we make a different distinction. As an owner, I have a real right. Ownership is a real right, and you've learned that it's the most comprehensive real right that you can have over your property, although of course, that right can be limited. It can be limited by the law, but also by the rights of others. Then if we talk about a holder, For me, the easiest way to understand the distinction is to immediately refer to examples. And here the easy example is to say that as a holder is somebody who borrows something, for example, a car. So if I am driving around in a car that doesn't belong to me, but it's my friend's car, I can be classified as a holder. And as we go along, you will see that a holder has the intention of deriving some kind of benefit from that thing. So for instance, if my car breaks down and I have to take it in for a service and I really need a car, I can borrow a car from my friend, but that doesn't make me the owner. It gives me some kind of real relationship towards that thing, but it's not ownership. Okay, then our third little car here is a car that belongs or that is controlled by what we classify as a possessor. And there, our easiest example is a thief. Now, you will find in study unit 8 that when we talk about a possessor, but it's very important to remember, when we talk about a possessor and we think about the example of a thief, it's only when we distinguish between ownership, holdership, and possession. In other words, there you must not think of an owner with the entitlement of controlling or possessing his or her own thing. When we say possession is always unlawful, it's only when we distinguish it from ownership, holdership, and possession. And there, our best example is a thief. Now, once again, I want you to remember that already this overview is given in study on page 13 of study unit 1. It's diagram 2. Please go and look at that diagram. Make sure you understand it, especially in view of what I said now about this distinction. Okay, now this is just a continuation of the discussion of why we make this distinction. Ultimately, as you heard before, the law doesn't give the same consequence to these three different relationships. And if I can give you advice, this little picture that you see on the screen here, if you have this in mind while you study this study unit, having examples of persons classified as an owner, a borrower, or a thief, or therefore an owner, a holder, or a possessor, if you have this in mind, as you go along, you will see that it really makes understanding the study unit much easier. So what I did here on this screen is just to give you an example of an owner. You can own a car, which is a movable thing, but you can of course also own land, or here it's a little house, but of course the house forms part of the land, which is an immovable. You can, of course, borrow a car from a friend, or you can lease a car from a rental agency, or you can borrow anything from a friend that is a movable thing. You can borrow a cell phone, any movable thing. But, of course, you can also be a lessee of an immovable property. Both these are holders. You are a holder of that car, but you can also be a holder of this house that you are renting from somebody. And then if we talk about a possessor, an example, already I said the best example would be a thief, a person who drives around in a car that he or she stole. That person will always be classified as a possessor, and that is also a mala fide relationship. We will get to that. But then a person who stays on land, or maybe in a rental property without permission of the landlord or the owner of that property, Such a person is classified as an unlawful occupier, but also but this is also classified as a mala fide possessor. So with these very basic little illustrations in mind, please, before you move along, you can pause this recording and go and have a look at the diagram on page 13 of your study guide, where the different real relationships are set out. Make sure that you understand this before you listen further. Okay, now on the screen you will see certain terms. By no means am I saying that these terms are the only ones that you must look at. It's just certain words and aspects of this study unit that I really want you to make sure that you understand. So already I said that possession always has some kind of physical element, but then also a mental element. For example, a holder must be in physical control, but as I said, the holder has the mental element of deriving a benefit. Whereas the possessor, when distinguished from ownership, is a person who controls with the intention of an owner. When a thief drives around in a car, that thief never intends to just derive a benefit. Such a person almost pretends to be the owner. For example, if the thief tries to sell the car, that person will definitely pretend to actually have the authority to be able to sell that car. Okay. Then I write here that control of an owner as opposed to that of a borrower or a thief. What I'm trying to say there is that, of course, when you own something, you have a different relationship with that exact same thing than the relationship that a borrower or a thief will have. You can have 3 cars standing next to each other in a parking lot. The one being owned by a person, the one being a stolen car, and the one being a rental car. The relationship there is much different in those 3 instances. Okay, I want you to go and have a look on page 150 to 153, where you will find a full discussion of the mental elements, and make sure that you understand what that mental element means. There's also a diagram. That diagram is partly taken from the diagram referred to earlier on page 13. There on page 153, I write here that make sure that you look at the examples of bona fide and mala fide. Now, once again, if you want to understand this study unit the best, refer to the examples and make sure that you understand the examples. If I can take one example, and once again it refers to the thief. If you look on the diagram, in the diagram on page 153, you will see there's sort of, in the middle of the page, you will see the broad distinction between possession and holdership. And then you will find examples of mala fide and bona fide possessors, bona fide unlawful holders, and mala fide unlawful holders, and so on. And there in the middle, we write there that mala fide possessor controls the thing while he or she is aware of the fact that he or she is not legally recognized as the owner of the thing. For example, a thief. If we look at another example, a bona fide unlawful holder, it's just next to mala fide possessor. That is someone who controls a thing unlawfully, but that person is unaware of the fact that he or she is controlling the thing unlawfully. And there the example that we are giving is a lessee who is leasing a property, but the lease agreement is invalid. So that person thinks that he or she is staying in a property with a valid lease agreement, but while in fact that is not the truth. And yeah, I want you to go and look at all those examples, and you must be able to identify and classify these different types of holders or possessors. Okay, I think one way of making really sure that you understand this classification is if you go and look at your one of your prescribed cases, the Hendricks case. Remember, if I can just quickly mention that, all cases that we refer to in the study guide must be studied to the extent that they are referred to in the guide. In other words, if we just refer to a case and we just have one important aspect of the case, for example, requirements of a remedy, you must know that name of that case. But in your 101 tutorial letter, there are certain cases that you must go and read yourself, and the Hendricks case is one of those. Now, the Hendricks case really have very interesting facts. I'm sure by now you've all read it. And the reason why we prescribe that case for you to read is because of the very interesting facts and the way that it deals with different rights and also real relationships. So if I can just quickly recap, we had there's a property, there's a married couple, and then there's an older person, which I call Mrs. Annie. So what happened here was that Mrs. Annie sold her property to her son Graham, who later on married to Margaret. Instead of moving out, Mrs. Annie decided to register a personal servitude, which was a right of habitatio, which allowed her to stay on in this house. So Graham was the owner, but Mrs. Annie had the right to stay there. A personal servitude was the basis of her right, a right of habitatio, but that, of course, is a limited real right. So if I can just provide maybe just a quick explanation of that, just to refresh your memory. Remember that ownership, which in this case was Graham, but they were married in community of property, but we can just say Graham and Margaret owned the property. Just to keep it simple, of course, there was some breakup in the relationship, but that's not really relevant for just the explanation. Graham had ownership, in other words, the most complete real right that you can have over a thing. But Mrs. Annie had a very strong right, namely a personal servitude, which is a limited real right. Why do I emphasize this? It's just to remind you of the limitations that can be put on ownership. And in the Hendricks case, it was illustrated very clearly how ownership can be limited. Because remember, Graham stayed here with Margaret, but Mrs. Annie also stayed here because she had the right to stay there. And then when the relationship between Graham and Margaret went into troubled waters, and it became very difficult for the mother to stay there, of course, the mother succeeded with an eviction order against Graham and Margaret, even though she wasn't the owner. Now, the reason I'm referring to this case in Study Unit 8 is not to fully explain the basis of personal servitudes and the operation of that. I'm just providing some background. What I want to get to is to understand how these different persons can be classified. If we go and look at who the owners were, that's easy. Graham was the owner. When he got married to Margaret, obviously Margaret became co-owner because of the way that they were married. If we ask ourselves, what type of real relationship did Mrs. Annie have towards this property? Remember, she was not the owner. Was she a possessor? Was she a holder? What kind of relationship did she have? Now, hopefully it's very easy for you to understand that her relationship with this property was obviously bona fide, but she was a holder. She had the intention of deriving a benefit from the property. You will also see there that we refer to the example of a usufructuary in that diagram on page 153. So once again, this is just an overview and just a mention of a few aspects of this case. It's not a full discussion. Please make sure that you read this case and that you understand why I'm referring to it here as well. Okay, so that brings us to the next study unit, to study unit 9, which deals with the remedies that can be used by possessors and holders. Remember, already we have dealt with the remedies that apply to the protection of ownership. You've dealt with that in full, and you must make sure that you understand and that you know how to apply the remedies. It's a matter of understanding which remedy applies under which circumstances. The best advice that I can give you is to look at all the questions that we have in the study guide. And then most importantly, in study unit 6, that's where we deal with the protection of ownership, is the summary on page 130 of the study guide. Now, if you can open your study guide there, it's that long table that we have there on page 131. That table, you must make sure that you understand it and that you know the different categories and the different remedies. The most important column, if I can call it like that, when you look at this study unit, but also at study unit 6, is the column that says who can claim against who can claim. Now, if you look there in the third column that says who can claim, do you see there when we talk about the reivindicatio, who can claim? It's the owner that can use the reivindicatio. If we look at the interdict, an owner can use the interdict, but a lawful holder can also use the interdict. So if we go back to the example of Mrs. Annie and Graham and the Hendricks case, remember I said earlier that Mrs. Annie was a lawful holder. So if ever Mrs. Annie needed to use the interdict or institute the interdict, even though she wasn't the owner, she would also have been able to use that. And in that column you can go along and you can see there that the declaratory order is available to an owner, a possessor and a holder. Then the actio negatoria is only available to an owner. The condictio furtiva is available to an owner or to a person with a lawful interest. Now, who will a person with a lawful interest be? You will see us referring to that in study unit 8 and 9. If I buy something on credit, which means that I'm not the owner of that, for example, I buy a car, but I'm repaying it in installments. And once I pay the last installment, I become the owner of that car. Then I have a lawful interest. If somebody steals that car from me, I will be able to institute the condictio furtiva to reclaim that car, even though I'm not the owner yet. And go and have a look there. That diagram is very comprehensive. But what you will not find in that diagram on page 131, you will not find the spoliation remedy there. Now, why won't you find it there? If you look at the title of study unit 6, it says protection of ownership. Now that's why I said earlier, remember your table of contents is something that you must always look at before you start with a new study unit to make sure that you understand where you are at a certain stage of your studies. Are you busy with ownership Are you busy with possession and holdership? Are you busy with servitudes, real security? What are you busy with? Now, if we get to study unit 9, we're talking about the remedies that you can use to protect possession and holdership. Now, the most important thing, the most important remedy there, of course, is the spoliation remedy. Now, for me personally, this is the most interesting part of property law, and it's the part of property law that I personally like the most to explain, and I really want you to make sure that you understand how this remedy operates, and that you have a very clear picture in your mind of when this remedy becomes relevant. Now, the first case that obviously comes to mind when we talk about the spoliation remedy is Nino Bonino versus De Lange. Now, you can go and read what is written in the study guide, but the facts of Nino Bonino versus De Lange is a set of facts that you might have heard many times before. It's the classic example of a person renting a property and then for some reason either not paying the rent or doing something that's actually contravening the lease agreement. And then something that we've all heard before is that the landlord comes and changes the locks of that property to actually make it impossible for the person who's renting or leasing to access that rental property. Now, I know that many of you have heard this before, and I'm sure that some of you have also heard that people actually assume that that is not something that's really wrong to do. But of course, that comes down to taking the law into your own hands, which is ultimately the purpose of the spoliation remedy. Now, if you have studied the study unit already, you would have seen that the purpose of the spoliation remedy is to avoid self-help, to prevent people from taking the law into their own hands. If we just talk about that example of changing locks and actually preventing somebody to access a rental property, of course, the correct procedure would be to apply for an eviction order. And that is a court order. Section 26 of the Constitution tells us very clearly that no one should be evicted from his or her home without a court order. That our Constitution makes provision for that. Now, so purpose, please go and make sure that you understand what the purpose of the remedy is, how it functions. It's a remedy where the merits of the case is not considered. Only the requirements are applied. Now, why don't you think you might ask, why does a court not consider the merits? Because surely, if, for example, I'm a lessee of a flat and I stop paying the rent, surely then you might say that the landlord should be able to evict me. Yes. There should be a procedure, and there is a procedure that you can follow, but do follow the correct procedure. Do not take the law into your own hands, because if you do that, the spoliation remedy becomes available to me as lessee to restore my control or my possession. Now, you will notice that when we talk about the spoliation remedy, we refer to control. That is just to say that we are not here talking necessarily about possession, which when we distinguish it from ownership, we classify as an unlawful form of control. But that is not a problem to refer to possession here either. You are welcome to say that the purpose of the spoliation remedy is to restore possession. Okay, now what is important to remember, and that I actually already referred to when I spoke about study unit 6 and the remedies that are available to protect ownership. Just make sure that you understand that the reivindicatio is used to protect ownership. So if somebody, for some reason, has property that belongs to me or has a thing that belongs to me, I can institute the reivindicatio to get that, whatever the case might be. If somebody borrowed a car from me, and that person for some reason is now not returning that car back to me, I can institute the reivindicatio because I am the owner. I can prove the requirements. I'm the owner. That car is in existence and I can identify it, and it is in control of the person who took it from me or who borrowed it, whatever the facts might be. But just make very sure that when you read a set of facts, that you understand that when you deal with ownership and you deal with protecting ownership, that the reivindicatio becomes the relevant remedy. But when it's a person, for example, a tenant, or maybe a person who's occupying land unlawfully, that person is not the owner of that property or that land or whatever your set of facts is, or a flat, an apartment. But when that person's control is taken away from that person unlawfully, in other words, when the owner takes the law into his or her own hands, then the spoliation remedy becomes the relevant one. Now on page 162, the requirements are dealt with. In other words, peaceful, undisturbed control or possession of the thing, and then unlawful disturbance of such control. Go and have a look at the requirements. If you are asked to apply the spoliation remedy, make sure that you use the correct requirements. They've been formulated in the Nino Bonino versus the Lange case. So whenever you are asked to answer a question on the spoliation remedy and you are referring to the requirements, you will earn a mark for referring to the Nino versus Bonino, Nino Bonino versus the Lange case. Now, certain valid defences may be raised against the spoliation remedy. I want you to go and look there at page 164 and to 166. There are numerous cases that we referred to, especially there with the defence of impossibility. Make sure that you understand those cases. Go and have a look at what is written there. Remember, you only have to know what is written there to the extent that we discuss them there. The defence of impossibility became relevant in City of Tshwane Metropolitan Municipality, and there I want to link that case to the short question here. Is the spoliation remedy relevant today? It's very relevant. Whenever there is unlawful removal of persons who are not owning land or housing of some whatever form, this case is a very good example of that, and the spoliation remedy is used very often, and it's still a very relevant remedy. Now, the other remedies that I already actually referred to when I referred to page 131 and the diagram is the condictio furtiva, the action for damages, the interdict. Those are all remedies that's also available to persons who are not necessarily the owner of property or land or whatever the case might be. There I also referred to study unit 6, page 131. Now, a new case that we've prescribed this year, it's a very recent case. It's Bischoff versus Welbeplan Boerdery. I want you to go and make sure that you read that case. It's a very, very short decision. It's a Supreme Court of Appeal case. The facts are very straightforward. It once again refers to persons who are not owning, obviously, but persons who are leasing certain parts of a farm. It illustrates very well how the requirements for a successful reliance on the spoliation remedy can be interpreted or should be interpreted. Paragraph 12 there is very important, and it actually sums up very nicely what happened in that decision. And then I just wrote here eviction and reivindicatio, just to once again remind you that the basis of an eviction order is the reivindicatio, although, as you know, different pieces of legislation apply. For example, the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act by, and then also the ESTA Act, and also the Labour Tenants Act. All of those statutes are discussed also in Study Unit 6 briefly, but obviously later on in the study guide you can read more about them. But just always keep in mind that when an owner wants to evict persons who are occupying land unlawfully, the correct eviction procedure must be followed. But yeah, I'm leaving that this decision to you. The facts are very interesting. I want you to go and read it, and I want you to make sure that you understand this case, and also that you understand why the spoliation remedy was not successful or even relevant in this decision, although it was applied, although an application for the remedy was made. And then that brings me to the end of this really brief overview. I hope it was helpful, and I hope that you learned something, and that what I said to you made sense to you, and that it will help you in your preparation.